Paradise Lakes Condominium Association.
Good afternoon.
Hi, how are you? We have everybody? Judge Kelly has turned her camera off for a moment, but she's still there.
Good afternoon.
Hi. You can start whenever you're ready.
May it please the court. My name is Margaret Brennan Corioso, and I represent the appellant, cross appellee, Mr. DeLong. Your Honors, I'd like to reserve 2 minutes for rebuttal,
Sure.
if you may. Your Honors, this case is about a Paradise Lakes Homeowners Association that decided that they wanted to terminate the timeshare interest of Paradise Lakes. And instead of negotiating a good faith buyout with the timeshare owners, they decided to change the methodology of calculating the assessments. Prior to 2014, all of the assessments for a 1 week timeshare interest had been approximately $300 for the year for the 1 week. In 2014, after they changed the methodology, the amount of the assessments in an effort to ooze the timeshare owners out of the property rose to $12,700 for a 1 week interest in the timeshare. At that point, my client had 2 options. One, to pay the exorbitantly high assessment, which was over 4,000% higher than it had been in any of the previous years, or to contest the validity of the lien. My client did contest the validity of the lien, and in fact has been doing so for the past 10 years. As Your Honor, Judge Northcutt probably knows, I think you were on our first panel back in 2016, the first time that this case came in front of the court. My client has continuously represented that the amount of the assessment should be the $312 and has on multiple times tried to pay that amount into the court registry. However, the trial judge...
Ms. Corrigan, so where do we stand now? Are you contesting the foreclosure of the lien? Are you contesting the...
We are contesting two things. So we are contesting, after multiple hearings, the trial judge finally did have a hearing on the amount of the assessments. However, what had happened prior to that is the trial court entered a judgment just as to liability without determining the amount of the assessment. Then it went back to the trial court. She held an evidentiary hearing on the amount of the assessment and agreed with my client that it should be the $312.
But your client, there's no dispute that your client paid nothing, which was not the correct amount of the assessment either, correct?
No, that is true. But unfortunately, the only defense you have for an assessment is to pay the amount in full or to contest it. So he did contest it. And then 2 times, as shown in the record on page 1200 and also on page 1880, he tried to put the amount that he alleged was owed into the court registry, the amount of the $600 both times. So he was willing to make that amount. The trial judge denied the motion, would not allow him to put that amount into the court registry. So it went back to the trial court, and that was our concern, was that the trial court needed to determine the amount of the assessment to determine first whether it was valid before entering the liability. It came back, she'd already found liability, and then ended up finding in favor of our client that it was actually the amount that we said. So we're appealing that final judgment, and we're also appealing the order granting the prevailing party attorney's fees. So although the court found that the actual amount of the assessment was the amount that my client defended, she entered an order finding prevailing party attorney's fees before determining what the amount of the assessment was, and found that the association was the prevailing party because my client owed something. The trial court at that point did not do any of the analysis regarding the patient row factors, the 8 factors, including the evidence that she had heard. And we objected at that time and asked if she could wait till after she finalized what the outcome was. She continued and made the ruling, hearing from an attorney that was discussing what the row elements was, on the basis that the association was expecting to recover over $200,000 of assessments, when in fact the trial court only awarded the $312 per week. So the trial court made the determination.
the association was also foreclosing on a lien, correct? It wasn't just trying to recover assessments, it was foreclosing on the lien.
It was, but in order for there to be a lien, you have to determine that the amount is valid. So,
Well,
I mean, the association has the burden.
But the court ruled in favor of the association on the foreclosure.
Yes, but in order to determine that the foreclosure was correct, they had to prove the amount.
So
And
you're challenging the foreclosure as well as the amount of the lien.
the foreclosure, the amount, and the attorney's fees. Yes.
That's
Your Honor.
what I'm going to get straight.
Yeah, thank you, because I was a little confused here. I want to make sure I understand. You're saying that the foreclosure has to be reversed, even though your client owed some money and didn't pay it, that the foreclosure still has to be reversed because
So the foreclosure has to be reversed.
Wait, let me get this out. The foreclosure has to be reversed because your client offered to put money in the court registry, and that's why there was no payment. I mean, what's the defense to the foreclosure?
No, the defense is,
well, regardless of the amount, he didn't pay anything.
no, the defense is that the lien was invalid. You can't just say you have a mortgage of $10 million, and in fact, you only have a mortgage of $1 million, but because you didn't pay the $10 million, that now they can foreclose. You have the association has an obligation as part of their complaint to actually say, this is the amount of the assessment and prove that, and it was not paid. So my client shouldn't have to pay $12,700 in order to contest the validity of the lien. The association has the burden to prove by competent substantial evidence what the amount of the lien is. And then if you look at many of the cases regarding homeowners associations, and this is a little bit different because it's a timeshare, and so it gets a little bit confusing. But if you look, for example, at the Sarr versus Wesley case, 68 Southern 3rd 418, there a condo association brought an action against a homeowner for unpaid assessments, and the court entered judgment in favor of the association. The homeowner alleged that the amount was incorrect. On appeal, the 4th DCA said that the claim of the assessment was incorrect, was overstated, and was not a proper claim. And the court ended up reversing to the trial court to enter a judgment in favor of the homeowner because the amount was incorrect, and said that the accounting measures of the association were woefully inadequate. That's very similar to what happened in this case.
Well, explain to me, Scorioso, what was the basis for the court's conclusion that the correct amount of the assessment was $311.72 per timeshare week for all of those years?
Just to clarify, it was the court found that the assessment was $312 per week.
Well, I see $311.72 in the foreclosure judgment.
Yes.
Rounding
I
up,
meant that
per
yes.
week, for each timeshare week for a bunch of years. How did the court
and
reach
we're
that?
actually contesting that the court shouldn't have entered for the multiple other years because the only lien that was in front of that was pled was the 2014 lien. However,
Okay. How did the court come to that conclusion that that was the correct number?
The court determined that the amount shocked the conscience as far as a court of equity as to the amount. She actually talked about how she had a ranch herself that had thousands of acres and didn't even come close to having assessments of that amount for a month or for a year, and said, so what had happened, looking back, there was evidence presented as to the budget for the timeshare, how the association came up with the amount, so the new amount. So the association basically artificially inflated the budget so that it showed. And if you look, you can see a copy of the budget on record, page 524. There, the budget that was presented for the first time in 2014 showed that there was a total amount due was $2,594,000.
Wait, because I think that was challenged in the answer brief, that's really not the way to read the budget. And that really what the expenses were like 12,000, 13,000, it varied from year to year. But the reason that your client's assessment was so high is because rather than dividing it between all the timeshare units owned by the association and the 2 that your client held, your client's 2 units were assessed for all of the expenses for the timeshare.
That is correct. That's what the association argued. However, the budget where they came up with the amount of the 12,000, they inflated it to the $2.5 million so that they could comply with the timeshare statute. So the timeshare statute is different than the condominium statute. If they were applying this under a condominium statute where somebody lives there for the whole entire year, that would be the appropriate way to go about it. But the timeshare statute, which is 721.15, provides that each timeshare, like the allocation of the assessments has to be reasonable to their interest owned in the property. If you think a timeshare owner only has access for 1 week of the year, they don't have access for all the other weeks. Other people have access for all the other weeks. They're not ever supposed to be responsible for the assessment for those other weeks. A condo association, someone lives in a condo, they have access the entire year. So when you buy,
but the statute doesn't give a judge to decide what that number is, correct? As I'm reading the provision that I think you're referring to, which is 1B of that statute, says the allocation of total common expenses for a condominium or a cooperative timeshare plan may vary on any reasonable basis. And I'm assuming that means may vary on any reasonable basis according by the association board, including timeshare size, unit type, et cetera, et cetera. And then there's the last phrase, and I'm not quite sure I understand it, because I'm going to ask your colleague this as well. It says it can vary on a reasonable basis, so I assume that the board can choose that basis if it's reasonable. If the percentage interest in the common elements attributable to each timeshare condominium parcel or timeshare cooperative parcel equals the share of the total common expenses allocable to that parcel. What does that mean?
Well, then it goes on, Your Honor, if you read the
next
sentence.
Okay, the next sentence kind of says the same thing.
Except
the share of the common expenses allocable to the condominium parcel may vary on any reasonable basis if the timeshare's interest share of its parcel's common expense allocation is equal to that timeshare interest share of the percentage interest in the common elements attributable to such parcel.
Right. So
How
exactly.
do you apply that and get to $311.73?
Okay, so looking at that, the timeshare interest would be the one over 51. Their percent interest would, the timeshare for each week is 1 week that's divided by the 51. So then if the actual expenses, which they were actually 67,000, not the 12,000, that should be divided by 51. Now, what the association did is they wanted, instead of, which this is the part that it doesn't make any sense for their argument. They said that we're going to divide it by 51. But in order to do that, we have to inflate the budget now to 2.5 to get to the 12. If they would have left it at the 67 and said, okay, now we're going to divide it by the 5 remaining owners to get to that. But that's not what they did. So they artificially inflated it to get to the amount that they wanted them to pay. So
if I take what you've said and divide 67,000 by 51,
then you get the 311.
No, you don't. And multiply that by 2 because you had 2 weeks, correct? You get $2,600, $26.27 and 45 cents.
No, the 12,000. I'm sorry, because there was 5 owners at the time. It wasn't just my client left at that time. There were still 5 owners. So if you divide the 67 by 5, and then you get the 12,000, and then you divide that by the 51, you get the 311. So he was not the only one left at the time that this came. There were 5 owners. So they divided it by 5 to get the 12,000 for each of the owners. And then the 151 would be the 311 out of that. And actually, if you look also at the legislative history regarding this statute, which I outlined in my reply brief, it actually said that you should that this should be treated differently than the condominium association, that it's a different interest. You don't go under 718. And yet the association has said that the reason they were allowed to do this is that the law changed conveniently on July 1st, 2014, which said that now the condo association doesn't have to pay for any units, but that's the condo association and a condominium association, not a timeshare. And the timeshare statute, if you look at it, it was never amended after 2013. So that new law does not apply to the timeshare. And again, like, they're convoluting the fact that there was a timeshare association and there was a condo association. They are not to be treated equally. You know, this person only has an interest for 1 week as opposed to somebody that has an interest for the full year. So looking at the legislative intent, and again, it's on page 19 of my my reply brief, it specifically says, if we look at the bill when it came into place, says that, sorry, let me find the language. That it amends the statute to allocate common expenses in a reasonable manner, different from the requirements currently applicable to all condominiums. And then also in the declaration that applies for this case for the Paradise Lakes 26.2, it also requires that it has to be divided as the denominator is 1 and the the denominator 51 and the nominator as 1. So it also is showing that this is how the division has to be, which is different than the condo association.
Well, then that statute, that subparagraph just say notwithstanding any provision in chapter 718 or chapter 719.
But it also said, the statute says that 721 would take precedence.
Well, it's notwithstanding any provision of chapter 718 or 719 to the contrary, the allocation is this. That's what it's saying, what you've said.
Yes.
Operates, and it trumps the provisions of the declaration.
No, the declaration, if we follow the language of the declaration, that's the same thing, that you do divide it, the 151. It's different than what the association is saying. So the association, in trying to comply with the statute, had to artificially inflate the budget to get to that. Also, even if that was the case, even if we were to say the association's right, how they came to their calculations, they didn't present competent substantial evidence even to show that they got to the correct amount. If you look at the budget, there are absolutely no revenue, cash flow. The only thing that's on there is liabilities. Yet the record is replete with the fact that the association was able to get back some of the timeshares and was able to sell some of the units, so that the record actually shows that they recovered condos in the amount of 20,000 and 40,000, and they didn't explain why that wasn't put in the budget. Now, if that had been put into the timeshare budget, then there wouldn't be this $67,000 of maintenance fees. They also admitted that
did you challenge that budget? And
Yes,
say, did you say as a unit owner, this budget is improper when the budget was,
well, no, that's another thing.
Notice.
They never provided a copy of the budget to the client. And that's part of the other problem, is that the client said for the first time, all of a sudden we went from having a budget where it was $300 a month to them not giving notice of the budget. So that was another problem that the judge had, that she found in making her determination on the record page 2346. She said that no notice was given of this change in the methodology, and that she was concerned that the client never received it. So we have the association saying we can make this change.
You're at your 2 minutes, so you can use it.
If I could just
or
quickly address the
later.
attorney's fees, I'll reserve 1 minute. So with the attorney's fees, we respectfully request that the trial court abused its discretion in determining prevailing party attorney's fees prior to determining what the actual outcome of the case was. At that time, the evidence presented was that the assessments were going to be over $200,000. And the trial court actually came back and found what my client had always said, that it would be the $311 that he was willing to pay. The trial court didn't make any findings regarding Roe on the outcome or whether the reasonableness of the attorney's fees regarding that. Actually, my client should have been the prevailing party. So we asked that this court, one, reverse the final judgment, remand it for the claim to get dismissed because the lien was invalid, and also reverse the order granting prevailing party attorney's fees and remand for the court to enter in favor of my clients and to do the required row factor analysis. Thank you.
Okay, Ms. Corioso, you'll have 1 minute left for rebuttal. And you'll speak quickly, I'm sure. Okay, Mr. Gurley, it's your turn. And let me ask you, as I first read 721.15 as I was reading the briefs on your counter cross appeal, but you didn't really reply to that argument that as it was raised by Ms. Corioso's client. What is your position on the relevance of 721.15?
Judge, our position is that it has no relevance for the following reasons, or that it has been complied with. And it's all based on this misunderstanding as to the change in assessments, as Judge Kelly pointed out, the basis for the increase in what Mr. DeLong was required to pay. Because the way that the assessments were charged in 2014, 2015, Mr. DeLong's unit week assessment was $311.72. And that is the same as all 204 unit weeks out there on the property. Everyone was assessed $311.72 in 2014, 2015 for their unit week. That is the assessment. And what 721.15 says is that we can't charge Mr. DeLong $311.72 and the next guy who owns a unit week $200. It has to be in proportion with their ownership. It has to be the same. And that's happened here, Judge, where the discussion
has to be in proportion to his share of the unit share of the his share of the unit's interest in the common elements. Correct?
Correct, Judge. So his assessment has to be consistent with his interest in the common elements, and he shares 1/204th of the common elements within the timeshare plan. And so his assessment has to be the same as all 203 other timeshare weeks. And it is here, it's $311.72, where we see the jump that Mr. DeLong is tacked on to his bill, if you will, Judge, is because then he has to pay for all the non-paying owners, the association of—
Well, let's come back to that. Let's come back to that.
Okay.
His unit's interest in the common elements did not change because there were no other owners of the other timeshares, did it? Of the other units?
No, it didn't, Judge. And his
So how does his then if his unit's interest in the common elements did not change, how come his assessment changed?
Because, Judge, we have to separate his weekly assessment versus what he owed and what was due. His weekly assessment did not change. It was the same as everyone else out there. It was $311.72 per week. His bill was higher because then he had to make up the shortfall that wasn't paid by the other association-owned units. So his weekly assessment is the same as everybody else and every other timeshare week. And what the statute says is that can't be different. We can't charge weeks 3 and 5, $311.72, and weeks 6 and 7, $125. No, because everyone has the same proportional share of the common elements. So his bill was higher because there was a shortfall based on the fact that we cannot bill the association, charge the association for their unit weeks. So he's obligated to make up that shortfall. But his assessment is $311.72. So his bill is $311.72 times 2 for the 2 unit weeks that he owns. Line item 2, the surplus from the non-paying group as part of the DBPR and declaration that says the association owned weeks don't pay assessments. So,
but does that declaration say he pays it? He pays this the overage or underage, I guess, whichever one you want to call it.
No, it says that the timeshare plan has their own separate budget and that the timeshare plan is responsible for their timeshare budgeted expenses. And we use the denominator of 51, numerator of 1, or in Mr. DeLong's case 2. And then it says the association doesn't pay for association-owned weeks. And this gets into the problem with the order that we have in front of us, but there's no one else to pay under that provision. Only the timeshare is responsible for its own budget, in the same way that the condo is only responsible for the condo budget. They don't charge the timeshare. And this community actually has 3 subdivisions. There's also an HOA component, and they have a separate budget, and they don't pay anything towards the condo or vice versa. So it's only the timeshare plan unit week owners, third-party owners, that are responsible for these budgeted expenses. And that carve out makes it abundantly clear in the declaration that it's not the association to burden either. And so as the number of third-party owners dwindled, Mr. DeLong found himself in a difficult spot. But again, his assessment was always equal to every other unit week out there. His bill was higher, and that's kind of the misnomer here, is that he was charged more than $311.72 to be certain, but it's because he had to make up for the deficit from the non-paying owners. But his assessment per unit week was the exact same as every other unit week out there for every budget from 2014 on.
So the allocation of total common expenses may vary on a reasonable, but I mean, we're using, assessment, but this is his allocation of the common expenses obviously clearly exceeded that percentage interest in the common elements, right? It became basically 100%.
It did become 100%. But again, Judge, I think the only way to read the statute, because only the timeshare plan owners are responsible for these amounts, is to say that his allocation is his assessment that's charged per unit week. It can't be his total bill, because he owes $311.72 per unit week. He pays for his 2 weeks, let's say, Judge. Now we have this shortfall of whatever the number is, $60,000 to use round numbers, and he's the only member. So it just goes back to Mr. DeLong. So it's just added as line item 2 on his bill. So again, I would suggest to the court that his assigned proportional share is exactly in line with the statute. And Judge, I think I can highlight the point by saying, if we had all third-party owners and no association-owned weeks, everything would be equal. He'd be 311 like all of his fellow owners out there. It's the second line item that comes as a result of the fact that the association was forced to acquire these weeks. That is what has increased what he owes. But his assessment that's allocated to him based on his percentage of ownership and interest in the common elements is the exact same as everybody else's from 2014 to 2023. His expense is higher because he's paying for everybody else, but all the line items per unit week are the exact same. And that is my reading of the statute. That's consistent with condo law, cooperative law, HOA law, and I believe it applies in this context as well, Your Honor. And so I'll move forward from that point, if no further questions there, Judge. And I've explained now how the association came to change its budget, or the basis for it, but it's important to note that that's the only defense that Mr. DeLong has raised in this lawsuit throughout. It's this idea that the association willfully fabricated its budget to kick him out, or was otherwise engaged in fraud or illicit behavior. And the reality is, Mr. DeLong challenged the way the association was budgeting pre-2014. They were paying assessments at that point. The association was paying assessments for association-owned unit weeks. Mr. DeLong challenged it with the Department of Business and Professional Regulation. And in a twist of irony, the division came back, the DBPR came back and said, yeah, they're doing it wrong, but you're supposed to pay more, Mr. DeLong. The association's not supposed to pay for unit weeks that they acquire as a matter of law and their declaration. And that was the precipice for the change, the instruction from the DBPR. And again, that construction, setting aside the statute, is directly consistent with section 26.2 of the association's declaration. It says explicitly, the association is not to pay for timeshare weeks that they acquire. And if they did so in contradiction to their declaration, we'd be here defending a lawsuit filed by the condo owners, because the association board wouldn't be following their own declaration, and they'd be charging the condo owners for timeshare expenses. So that provision in the declaration has to be followed. And again, Mr. DeLong's assessment was $311.72 in 2014, 2015. His bill was higher, but his weekly assessment was exactly that amount. And opposing counsel in the initial brief says, well, his assessments have always been between $200 and $400. This is outrageous. Interestingly enough, 2014, 2015, we're square in the middle of that. The budget hasn't gone up at all. The only thing that's changed is the number of obligated payers. The number of people liable for the assessment has gone down. The budget hasn't gone up. The amount of the weekly assessments has not gone up. So there's no evidence whatsoever of any willful misconduct, certainly, any fraudulent behavior of anything of the sort. There's a very logical and practical, and in fact, legally compliant explanation for the change. And it's that there's fewer people to pay the amount now. And eventually Mr. DeLong found himself liable for the full amount as the years went by. And this became a poorer investment over time as more people dropped out. And so that's the red herring defense, if you will, that we've kind of said, look at this $1 million number over here. But the $1 million number isn't the amount of their budget in any way, shape, or form for the reasons I described. It's $60,000. It's completely consistent with prior years. And so we go to a summary judgment hearing that turned out to be only on the issue of liability. And as was pointed out, there's no dispute that Mr. DeLong has not paid anything. There's no dispute that he's liable to the association for something, that the association had the right to lien for his non-payment. And we go before the court on summary judgment. I'll get to the association's evidence in a moment, but I think it's even more important to highlight the lack of argument or any presentation for the judge on Mr. DeLong's part. They've raised one affirmative defense, that's this willful inflation of the budget argument that I just explained does not hold any water. They were obligated to make the change both by the DBPR and their declaration. And Mr. DeLong, in support of that one affirmative defense alleging willful exaggeration fraud, there's a single affidavit signed by Mr. DeLong himself, and he says, well, my assessments are way higher than they used to be, so I know they're committing fraud. That's not sufficient to defeat summary judgment. That's not going to do it, particularly where we are years and years into litigation at that point. We're 4 or 5 years into a lawsuit. We've conducted depositions. I think Mr. DeLong, through his counsel, filed 5 requests for production. And the most they have is, look at this number, look how high it is, something wrong went on here. And again, the number is easily explained. And we compare that to what the association submitted, and that's an affidavit from Ms. Caruso, the property manager and a board member, that says, look, I worked hand in hand with the DBPR. I used their spreadsheet to do these calculations. They approved these budgets. I worked with our accountants. I worked with our then legal counsel to prepare these budgets. The affidavit from Ms. Caruso with the association's ledgers attached. It says, here's what he owes based on these budgets. It's all there. We have Ms. Caruso's deposition transcript where she explains everything that I just explained to the court in terms of why the allocation changed and what the basis for it was and how they started doing that in 2014 and onward, because there were fewer individuals who were liable for those amounts. So there's the association's evidence where we've shown the amounts due. We've shown the way they've conducted their budgeting. We've showed why the amount has gone up, the amount that he owes, not the assessment charged for his unit week, but the amount that he owes, why and how it's gone up. And there's no evidence of any willful exaggeration. That's the only thing that could invalidate this lien, is fraud or willful invalidation, or exaggeration rather. And on the flip side, we have the business judgment rule on the association side that says, you know, absent a showing of fraud, absent showing bad faith conduct, the association is entitled to run the business as it sees fit, and the court is not permitted to step in and change how the association runs its business, again, absent fraud or some sort of willful misconduct. And on summary judgment, there's absolutely zero evidence, suggestion, any possibility of admissible evidence from Mr. DeLong that the association's engaged in that conduct, other than look at this number, but that number is easily explained. The court did reserve on the dollar amount at that time, and the court was concerned about the total dollar amount, I believe for equitable reasons, as we'll learn later on following the evidentiary hearing. But the court says the lien's valid, even if the numbers are wrong. Under Pash versus Mahogany Way HOA, 4th DCA case, the numbers can be off, but the lien's still valid. Mr. DeLong has paid nothing. There's no question as to the validity of the lien. And so on we went to the evidentiary hearing. And here's where I think, you know, things went off the rails a little bit from our perspective, and we have a a counter appeal on this basis, but the court heard testimony from an accountant put forth by Mr. DeLong, who said, well, this is not the way you're supposed to be doing it, notwithstanding the fact that the declaration says that's exactly how you're supposed to be doing it. This accountant said no. And then a former DBPR employee who said the same thing, again, confronted with the declaration and said, well, you know, I see it differently. Had Mr. DeLong, and I highlight those witnesses because had Mr. DeLong presented an affidavit from those individuals or deposition transcripts from those individuals timely before summary judgment was entered, maybe they'd have a better argument here on appeal as to the appropriateness of the granting of that summary judgment motion. But none of that was before the trial court on summary judgment. I'd still suggest that that testimony is not relevant or persuasive, even on summary judgment. But again, none of that was before the court on summary judgment that was untimely. The court heard from our accountant who explained everything that I explained to the court in terms of the allocation change, that the assessment stayed the same per unit week, but the number of people responsible for it changed, and that's why there was the difference. We had our expert on attorney's fees testify, and we had a corporate rep go through to admit the declaration and to go through the ledgers and say, here's what he has charged and here's what he has not paid. And I believe it was Judge Northcutt that alluded to this initially. The trial court found that the assessments were entirely appropriate in the sense that they are legal and in accordance with our declaration. The trial court in its oral ruling said, I would be well within my right and authority to award this full amount based on the provisions in this declaration, that the association's entitled to it. And in fact, that's reflected in the final judgment that's on appeal here. The court says in the final judgment, the association's entitled to it. However, then the court disregards, the trial court disregards the declaration here and says, as a matter of equity, I think the dollar amounts listed are too high for an old timeshare week. And therefore I'm a court of equity and I'm going to alter these dollar amounts and reduce them from $12,000 a week, which again is comprised of Mr. DeLong's unit week plus the deficiency, and says, I'm going to reduce that down to just the 311. Your lien's valid. Everything you did was correct. Everything you did was within your legal right under your declaration in Florida law. But as a matter of equity only, I'm reducing the amount to what I think is fair. And so that's important when we talk about attorney's fees, is because the association absolutely prevailed. The court and the court explained its reasoning very clearly. The association was entitled to those amounts, but the court's reducing it as a matter of equity. Our appeal, our cross appeal, stems from the court's reduction of those dollar amounts. A trial court cannot rewrite a contract in this manner. The trial court cannot look at the declaration that Mr. DeLong entered into of his own free will when he bought timeshare weeks. He's presumed to have knowledge of this provision in the declaration. And then when the rubber meets the road and he finds himself liable for these assessments, the court can't come in and say, well, I'm going to relieve you of that burden under the contract because I don't think it's fair. One case that we cited is Beach versus Resort Hotel Corporation. It's the Florida Supreme Court case, and the summary of that is what I just stated. The court can't relieve an individual of that obligation because of the trial court's feeling that it's unfair. And then to take it a step further, if we want to talk about practicality and fairness and equity, well, the practicality of it is we're now left with a judgment that serves the association no practical purpose, because, and what I mean by that is as follows. We have a judgment that says Mr. DeLong's only responsible for $311 per unit week. So now we have a shortfall every single year from 2014. We have a deficit of tens of thousands of dollars because we're only getting $600 and something from Mr. DeLong. We have a huge deficit. Who do we go after to recover that deficit to keep the timeshare plan operational? Only the timeshare week owners are responsible for their budget and their expenses. So we're just assessing Mr. DeLong again. So if this judgment survives, then I just have to file another foreclosure action and another lien against Mr. DeLong to now recover what still isn't being paid. Because again, we're in this Pondetti where Mr. DeLong's responsible as the only timeshare week owner. If we reduce what he owes, then go back to the timeshare plan owners, it's only Mr. DeLong. We keep going in that circle. And again, as I noted before, from an equitable standpoint, we can't change what the declaration says. If the association does that, they're going to get by their condominium owners. They can't vote 11. That's not going to work. Mr. DeLong made what was ultimately a poor financial investment. I feel bad for him Timeshare units across the state of Florida have met the same fate over the last few decades. It's not unique to him. We saw a lot of it in 2008, 2009. It proved to be a bad investment. And he found himself liable for the full amount of assessments that can't be transferred to the condominium owners as a matter of law. And so we suggest that the court's judgment in that regard is an error, in that the court should have awarded the full amount of assessments that we were seeking at that time. The court cannot change the provision in the declaration on the basis of equity. That's not permissible under the law. As to attorney's fees, the court laid out exactly why we prevailed, that we were entitled to everything that we were seeking. It was only this equitable argument that reduced the dollar amount. The judgment as to attorney's fees, it addresses exactly the number of hours. It addresses the hourly rates and says that they were all reasonable. And then it says that the court considered the factors in row, and it says that it considered enhancement or reduction factors and declines to adopt those. And I think it's well explained in the judgment as to why the court made that ruling. The findings of fact in the judgment to support that are, again, that the lien was valid. Mr. DeLong's never paid. The association was entitled to everything they asked for under the declaration. And so the association substantially prevailed, and the court supported its position that there's no reason for a reduction. So with all of that said, Judge Roscoe.
I was about to tell you your 20 minutes are up, Mr. Gurley, and it sounded like you would come to that same conclusion.
Thank you, Judge. I'll wrap up right here. So we ask that the court affirm the summary judgment order, that the court reverse and remand the final judgment with instruction that the trial court needs to award the full amount of assessments that the association is entitled to, because the court cannot reduce that amount on the basis of equity, where there is a contract in place that requires us to assess those amounts exactly how we have assessed them. Thank you.
Okay, Ms. Corioso, 1 minute. You ready?
I'm ready. Yes.
Go.
Okay. First, Your Honors, counsel misrepresented what our affirmative defense was. Actually, it was that the claim was invalid, and therefore the association is required to prove by competent and substantial evidence that the claim was valid. Even if we were to agree that the 2.5 number was superfluous, they still had to prove at least that the $12,000 budget was. And if you look at the budget, which I'm sure anybody with any accounting would see, that they didn't include any revenue in there. All of the testimony at the hearing said showed that they were trying to get rid of the timeshare units. The trial court actually even in making the ruling on page 1532 says, I'm leaning towards bad faith here. There was testimony and email showing between the association and the DPBR that they were trying to get rid of them, and that they were ramping up the budget and purpose to get rid of the timeshare units. That is not fair. The business judgment rule does not apply because there's bad faith. And as the court noted, she was leaning towards bad faith. And then finally on the
so go ahead and finish up, because you're at one.
So the business judgment rule doesn't apply. First of all, it shouldn't apply on a summary judgment because there's an issue of fact. So the court shouldn't have done that on a summary judgment. Second of all, the court did make a finding actually that she was leaning towards bad faith. And then finally, as far as the attorney's fees, again, the trial court erred in entering that award before determining what the actual outcome was, and did not actually at that hearing consider the reasonableness of the fees with the outcome, and did not make specific findings of fact, which this court in Barada has said is required for the final judgment to make a written finding of fact regarding the reasonableness of the fees in accordance with the verdict. So for those reasons, Your Honor, I respectfully request that you reverse both of the judgments and dismiss the claim because the claim is invalid. Thank you.
Thank you both very much. In order to leave our courtroom, you click the button that says leave on your Zoom screen.
Thank you. Have a good day.
Thank you very much. Have a great day.
There you go. And that is the end of our docket. So the court is adjourned. And judges, you click the leave button too.